You've heard about the Corporate Transparency Act by now. I bet you have some questions. Trust me, we all have questions. You're in luck because we're going to review some new FAQs published by FinCEN earlier this week. So keep watching for answers to some of your most burning questions about the CTA and your reporting requirements. Hi guys, welcome to Presume Legal. I'm Misha Janice. I'm an entrepreneur. I'm an attorney licensed in New York and Florida. Thank you for joining me today. I've been presenting information about the Corporate Transparency Act for viewers near and far because I've noticed a lack of information. The Corporate Transparency Act is going to impact over 30 million small businesses in the United States. It's set to become effective January 1st, 2024. To that end, FinCEN, which is the Financial Crimes Enforcement Network, that's an agency under the Treasury Department, under the US Treasury Department, that has been tasked with implementing the Corporate Transparency Act. They have been publishing updates to the reporting requirements and answering a lot of questions, gaps in knowledge, basically. So they started issuing these FAQs several months ago, and a few days ago, they issued and published some new FAQs. As we get closer and closer to the implementation date, they're trying to publish more information that's applicable to, certain circumstances that people get into. So let's go over to the FinCEN website and review the top 10 FAQs that were recently published earlier this week and see if we can't get some answers for ourselves, right? All right. Let's head over there now. Bear with me because I haven't done a screen share before. Here we go. Here we go. Okay. So this is the FinCEN website. You'll see here it's FinCEN, FINCEN.gov. And this is the beneficial ownership information reporting FAQ page. So the first new question that was recently answered is, how will companies become aware of the BOI reporting requirements? Good question, because like I said, I notice a lack of information out there. People are very confused about what's required, when it's required, what information has to be provided to the government, who has to provide the information. There's just a lot of confusion out there in the public. So this is a good question. Let's see what they have to say. It says FinCEN is engaged in a robust outreach and education campaign to raise awareness of and help reporting companies understand the new reporting requirements. That campaign involves virtual and in-person outreach events and comprehensive guidance in a variety of formats and languages, including multimedia content and the Small Entity Compliance Guide. That Small Entity Compliance Guide is a PDF that's accessible to the public. It's very large. I don't see people going there to look for answers just because it's so cumbersome and it's almost like too much information almost. Going on, as well as new channels of communication, including social media platforms. FinCEN is also engaging with governmental offices at the federal and state level, small business and trade associations, and interest groups. FinCEN will continue to provide guidance, information, and updates related to the BOI reporting requirements on its BOI webpage, which is where we're at right now. And then there is a link where you can subscribe here to receive updates via email from FinCEN about the BOI, the beneficial ownership information reporting obligations. So like I said, you can go to the fincen.gov website and you can sign up to receive updates about this, or you can just hit that subscribe button, tune into my channel, and follow me because I will be providing updates for the masses. All right, let's go on to the next question. All right, here we go. B8. Who can file a beneficial ownership information report on behalf of a reporting company? And what information will be collected on filers? Now, you know that a reporting company is who is required to submit these BOI reports to FinCEN. A reporting company is going to be most small and medium-sized businesses in the United States. There are 23 exemptions that businesses can fall into, but most small and medium-sized businesses will not qualify for those exemptions. The entire purpose of the Corporate Transparency Act is basically to target the small and medium-sized businesses so that the government has the information on who is the beneficiaries of these small businesses in the country. So this question is asking who can file a report on behalf of these companies, the reporting companies. And the answer says anyone whom the reporting company authorizes to act on its behalf. It can be an employee, owner, or a third-party service provider may file a BOI report on the reporting company's behalf. When submitting the BOI report, individual filers should be prepared to provide basic contact information about themselves, including their name and email address or phone number. So if you're going to hand this reporting duty, the actual task, off to an employee, just know that that employee is going to have to provide his or her personal information. All right, the next top question is here. C5. Does the activity or revenue of a company determine whether it is a reporting company? The answer is sometimes. A reporting company is any corporation, LLC, or similar entity that was created in the US by the filing of a document with a Secretary of State or similar office, in which case it is a domestic reporting company, or any legal entity that has been registered to do business in the US by the filing of a document with the Secretary of State or similar office, in which case it is a foreign reporting company. That too, this is the second qualification, does not qualify for any of the exemptions provided under the CTA. An entity's activities and revenue, along with other factors, in some cases can qualify for one of those exemptions. And we know that that exemption is the exemption for large company operators. Is it large company operators? Large companies. There's an exemption for large companies. For example, there is an exemption for certain inactive entities. That's another exemption. And another for any company that reported more than $5 million in gross receipts or sales in the previous year and satisfies other exemption criteria. Neither engaging solely in passive activities like holding rental properties, for example, nor being unprofitable necessarily exempts an entity from the BOI reporting requirements. What are they saying? If you have a passive company that was just set up, for example, to hold real estate, you will not be exempt from the reporting requirements, and you still have to submit a BOI report. If you have a company, a small business that is not profitable, you still have to comply with the reporting requirements. So in those instances, the revenue or the activity, the level of activity or passivity of a company is not going to exclude those companies from the requirement. And the next question is a sole proprietorship a reporting company? The answer is no. Unless a sole proprietorship was created in the US by filing a document with a Secretary of State or similar office. So we just heard that definition. That's the definition of a reporting company. So a sole proprietorship is just a one-man shop, basically. One-man shop who, uh, is providing either services or goods, and it's owned only by one person. That person never registered themselves as a business per se with their state, never filed for an LLC or a corporation. Um, they do taxes under their individual name. An entity is a reporting company only if it was created in the US by filing such a document. Filing a document with a government agency to obtain an IRS employer ID number, a fictitious business name, or a professional or occupational license does not create a new entity and therefore does not make a sole proprietorship filing such a document uh, a reporting company. So basically, you can get an employer ID, an EIN number from the IRS. You can have a fictitious business name, and you can have a professional license. Those three things do not mean that you have an entity that is required to file a BOI report. Because in having those three things, any of those three things, you don't necessarily need to file documents with your state to formalize basically yourself as an entity. All right, let's keep going here. We're making pretty good time. All right, F8. Question: can a reporting company report a post office box as its current address? Answer: no. The reporting company address must be a U.S. street address and cannot be a post office box. So, if you have a reporting company and it currently only has a post office box and you don't want to use a street address, I suggest you go out and get one of those entities. Sign up with one of those third parties that allows you to use a street office, a street address. They'll often have a unit number or a suite number or something that you can use as the official address, because FinCEN is not going to accept a post office box address for a reporting company. Next question, F9. Have I met FinCEN's BOI reporting obligation if I filed a form or report that provides beneficial ownership information to a state office, a financial institution, or the IRS? Good question. And this is a question that that some of the challenges to CTA has raised. I've seen that in my research. People are saying, the government has this information already. I have to file my taxes for my company, so why can't they just use that information? No, that's not going to be acceptable. This says reporting companies must report beneficial ownership information directly to FinCEN. Congress enacted a law, the CTA, that requires the reporting of beneficial ownership information directly to FinCEN. State or local governments, financial institutions, and other federal agencies, such as the IRS, may separately require entities to report certain beneficial ownership information. However, by law, those requirements are not a substitute for reporting beneficial ownership information to FinCEN. So they're just making us do the busy work, basically. They're saying, we need this information directly from you, directly into FinCEN. We're not going to go looking through any other records that the government may have, or that the government even may have access to, for example, a financial institution or a state or local government. They're just saying, just give it to us directly. All right, moving on. Okay, so this is a question about this is a dating question. Not boy-girl dating, but how are we calculating the dates, basically? How does a company created or registered after January 1, 2024 determine its date of creation or registration? The date of creation or registration for a reporting company is going to be the earlier of the date on which, one, the reporting company receives actual notice that its creation or registration has become effective, or two, a Secretary of State first provides public notice such as through a publicly accessible registry, that the domestic reporting company has been created or the foreign reporting company has been registered. FinCEN recognizes that there are varying state filing practices. In certain states, automated systems provide notice of creation or registration to newly created or registered companies. In other states, no actual notice of creation or registration is provided, and newly created companies receive notice through the public posting of state records. FinCEN believes that individuals who create or register reporting companies will likely stay apprised of creation or registration notices or publications, given those individuals' interest in establishing an operating business or engaging in the activity for which the reporting company is created. What are they saying here? They're saying, if you're going to register or create a new entity through your Secretary of State or similar office, you're going to have the responsibility to make sure that you track that registration and you track to see when it's first, when you first get word that the entity has become registered. Here's my suggestion to you. After January 1, 2024, if you go to create an entity with your Secretary of State, each day thereafter, set a calendar reminder on your phone, set an alarm, check today, check the Secretary of State's website. I would say check every day to see if that registration has gone through. So if I go on January 1st, 2024, create a new entity with my state, I'm in Florida, so I go on the SunBiz website. I'm going to set an alarm for every day thereafter, January 2nd, January 3rd, January 4th, log on, check to see if those records are up yet. The day that it becomes up, you're going to have 90 days. You're going to have 90 days in which to file your initial beneficial ownership information report with FinCEN. And that is only in 2024. Okay. So you're going to be responsible. You're going to have to be responsible for making sure that you don't miss those deadlines. So once again, my suggestion is set an alarm to do it daily. Maybe it's the first thing that you do every morning after filing the documents with your state, first thing you do before you check your email, just go to the website to see if your company has been registered yet. Next question, H4. If a reporting company needs to update one piece of information on a BOI report, such as its legal name or any other one piece of information, does a reporting company have to fill out an entirely new BOI report? Good question. The short answer, TLDR, yes. But let's read what FinCEN has to say. Updated BOI reports will require all fields to be submitted, including the updated pieces of information. For example, if a reporting company changes its legal name, the reporting company will need to file an updated BOI report to include the new legal name and the previously reported unchanged information about the company, its beneficial owners, and if required, its company applicants. So not only will you have to, technically it's going to be an updated record since you filed the initial beneficial ownership information report already. You're going to be updating the report that you already created with the new information. But you're submitting all the information, both the new information as well as the old information. You're submitting it all anew, all afresh to FinCEN. Reading on, a reporting company that filed its prior BOI report using the fillable PDF version may update its saved copy and resubmit it to FinCEN. Okay, so I'm not sure what this fillable PDF version is. This is the first time I'm hearing about that. But it looks like maybe they're going to have a document, a PDF document that can be, that has fields that can be filled in, I'm assuming. I don't know. I haven't seen that yet. And that may be a way of submitting BOI reports. I'm going to have to look more into that because this is the first time that I'm hearing about this fillable PDF document. Anyways, if a reporting company used FinCEN's web-based application to submit the previous BOI report, it will need to submit a new report in its entirety by either accessing FinCEN's web-based application to complete. And we know that that web-based application, that web-based app is not going to be available until January 1, 2024, or by using the PDF option to complete the BOI report and upload it to the BOI e-filing application. So I'm assuming maybe that's just something that we're not going to see until the platform is finally finished and released for public accessibility. All right, so there are a bunch of questions, and I didn't include these in the top 10 just because there's multiple questions. It's in this case section about compliance and enforcement and the penalties and who's being held liable for the information that's getting submitted or for information that's not getting submitted. I'm going to do a whole other video on just that topic because I have a feeling that this is going to be a situation that a lot of people are going to have. And that is what happens if you can't get information that you need from beneficial owners. What do you do? Who's going to be held liable? What can you do? So stay tuned for another video from me on that topic alone. But moving on to the next top question Okay, is M7. Who can request a FinCEN identifier on behalf of an individual? Misha, what is a FinCEN identifier? Good question. A FinCEN identifier is a unique identifying number that FinCEN will issue to an individual or to a reporting company or to a company applicant after the individual or reporting company provides certain information to FinCEN. An individual or a reporting company may only receive one FinCEN identifier. So basically, if you are a person who has holdings in many companies, or maybe you have multiple companies, instead of having to provide the same information, the same personally identifiable information to each company and have each company, have to store the information. You may be worried about the privacy or data leaks or, just the security of where you're holding that information. You as an individual, you may go to FinCEN yourself and apply for a FinCEN ID, right? A FinCEN identifier. And instead of providing all your personal identifiable information to all of these other companies that you're associated with, you're going to go directly to FinCEN. You're going to apply for a FinCEN ID. You're going to provide FinCEN with your personally identifiable information. So the information that's going to have to be given is your full legal name, your date of birth, your residential address, um, your driver's license number or your passport number, along with a copy of your actual driver's license or your actual passport or some other like state ID. You're going to give that information directly to FinCEN so that you don't have to give it to, you know, this company and that company and this company that you would otherwise have to give it to. In return, FinCEN is going to give you a unique identifying number. You can provide that unique identifying number to these other companies instead of having to provide them with your personally identifiable information. Okay. So this question is, who can request a FinCEN identifier on behalf of an individual? And the answer is anyone authorized to act on behalf of an individual may request a FinCEN identifier on the individual's behalf on or after January 1, 2024. FinCEN identifiers for individuals are provided upon request after the requesting party has submitted the necessary information. And I just told you what that information is, right? Your personally identifiable information. Obtaining a FinCEN identifier for an individual requires the requesting party to create a login.gov account, which is tied to the individual receiving the FinCEN identifier. Individuals who receive a FinCEN identifier should ensure their login credentials, including email address and related multi-factor information associated with their login.gov account, are saved for future reference. So I just wanted to show you guys, they're saying that the first step in obtaining a FinCEN identifier is to get access to login.gov and create an account with login.gov. So let's go look at login.gov really quickly. And here we go. This is login.gov, public's one account for government. Wow. So I think we would go to individuals, use one account for secure private access to participating government agencies. One account, one password. Okay. It's probably pretty straightforward. So my suggestion in general is that everybody should try and obtain a FinCEN identifier for themselves. I plan on getting a FinCEN identifier because I am going to be a beneficial owner on multiple companies that I'm associated with, and I would rather just give those companies an identifier rather than have them, in possession of personally identifiable information. So I suggest everybody just go ahead and go to login.gov, and you can do this. You can do this part before January 1st, 2024. Go ahead, go to login.gov, set up an account, and then after January 1, 2024, go to FinCEN and get that FinCEN identifier for yourself or for somebody else, somebody that you have authority to act on. For example, if you have a power of attorney for somebody, you are able to, you should be able to, depending on the power of attorney, you would be able to obtain a FinCEN on behalf of that person. And our last question that we're going to go over today is N2. What type of evidence will a reporting company receive as confirmation that its BOI report has been successfully filed by a third-party service provider? So we know that there will be third-party service providers submitting BOI reports on behalf of entities that they have engaged with, right? It can be a law firm. It can be one of those companies that forms entities, form entities in all 50 states, blah, blah, blah. It could be one of those companies. It could be a company that specifically is targeting specifically for CTA BOI reports. So if you use one of those third parties, and remember, you're not required to use a third party. You are able to yourself go to FinCEN directly after January 1, 2024. You're able to go to FinCEN directly on behalf of your own entity and submit your BOI report. You do not need to use a third party. But if you do use a third party, this question is asking, basically, do you get proof that the report has been filed on your behalf? The answer is the BOI e-filing application, available beginning January 1, provides acknowledgement of submission success or failure, and the submitter will be able to download a transcript of the BOI report. The reporting company will need to obtain this confirmation from the third-party service provider. So the answer is whoever is submitting the report, if it's a third party, they will get a confirmation that the report has been submitted successfully or it hasn't been filed successfully. Hopefully, they will forward that proof to the actual entity that they're filing on behalf of. If not, you're going to be required to follow up on your own. And it's going to be important that you get the receipts. Get the receipts, get the documentation, get the proof. Just save it in your computer, print it out, save it somewhere safe so that you have proof that your beneficial ownership information has been filed timely, and it has been successfully accepted. So those are the top 10 questions in these updated FAQs published by FinCEN that I have curated for you guys. If you have any additional questions, feel free to put them in the comments and I will do my best to address them. Just keep in mind that there's still a lot of questions, and FinCEN is still working a lot of issues out, and they're going to continue to work issues out. So there are still some things that, there are no answers for just yet. But I will do my best. If there are answers out there, I'll do my best to, to find those answers and answer them in the comments below. Like I mentioned before, if I've done this series on the CTA, there's an entire playlist at this point. I am going to continue providing updates and providing information about the CTA and the reporting requirements for small businesses. If you want more information on the CTA, whether it applies to your business, how it applies to your business, what the requirements are, what the information is, and who needs to be reported, check out that playlist and follow along. Subscribe to the channel so that you are up to date and that you can easily, comply with your reporting requirements. You'll know exactly what to do, and you won't have it be a huge headache, a huge burden over your head. You have better things to do. We all have better things to do, but this is something that is going to impact so many people, and so many people yet have to hear about it. So if you're a small business owner, you want legal tips, updates, general advice about how to proactively protect your assets, hit that subscribe button, leave me a comment to say hello, and stay tuned. Until the next drop, peace.